Hi, I'm Natalia Angelini.
And I'm Garrett Horrocks.
Welcome to Helen Estates. You're listening and watching episode number 610. Today, we're going to be discussing a recent decision that Garrett and I found interesting. It's Marion L. Carroll and TD Bank case, and a link will be up on our site.
Yeah, so this is a Court of Appeal decision from earlier this year in January 2021. It was an appeal of a decision from March of last year, March 2020, which was the pre-COVID times or early COVID times. It was, so the first instance decision was a Rule 21 motion brought by TD Bank. So initially, this was an application brought by Ms. Carroll, who was a senior compliance officer and manager at TD Bank, who was responsible for policy oversight, for regulatory oversight of a number of the TD Bank subsidiaries, including mutual funds. And she had noticed initially, or she had noticed over the course of her tenure there, that TD Bank and its subsidiaries appeared to be engaging in transactions on mutual funds that might not have been in the best interests of some of their clients, and earning considerable fees as a result of trades that they were making that were not consistent with their obligations as trustee of the mutual funds. So Ms. Carroll, she tried some avenues of redress internally with the bank. She went to some of her superiors and attempted to explain the discrepancy that she noticed, and she appeared to be brushed off. And she was eventually dismissed from her position in October 2014, and eventually essentially took matters into her own hands and brought this court application in an attempt to seek standing to compel TD Bank to pass its accounts as trustee of mutual funds.
Yeah, and it was interesting. I think it was only 2 weeks after she was dismissed that TD Bank settled the matter with the Ontario Securities Commission for a payment of about 14 million.
Yeah, exactly.
It looks like her efforts
were in vain. Yeah.
Yeah.
So in response to her application, the bank brought what's known as a Rule 21 motion, which allows the court to make a determination on a legal issue, a discrete legal issue brought in a broader application, if the court feels that a resolution of that issue might substantially shorten or dispense with the need entirely for the broader trial. So
right, and these motions are, we don't often have them in our area of practice because there's no evidence permitted, right? It's purely legal argument. So it's interesting in this case that TD Bank took that route, and I know you'll get into it, but they ultimately took it successfully, but it certainly can curtail, right, the length and time and cost of getting to a trial.
Yeah, exactly. And then the bank's whole position in this motion was that Ms. Carroll couldn't possibly succeed on her application to compel TD Bank to pass its accounts because she lacked standing to seek any of the relief that she was seeking. So she was not a beneficiary or an owner of any assets of mutual funds or which were managed by TD as trustee. So she could not possibly, the court would not grant that relief because she was not in the position to obtain that relief. Essentially, she did not have the standing to bring that relief to bring that application in the first place. And the court ultimately agreed with her, and they granted the Rule 21 motion on the basis that, contrary to her assertion that the court has what's known as inherent jurisdiction to supervise the administration of trusts, which is true, that can't be supplanted by an absence of standing. Essentially, the court wasn't prepared to find that, even though the court has its own jurisdiction, an inherent jurisdiction of that to oversee and ensure the proper administration of trust, the court still said that relief has to be sought by someone who has the standing to seek that relief. So someone essentially with a financial interest in that trust. So beneficiary, or in some cases creditors, will be granted that standing. Essentially, the court dismissed her application on that basis.
And in these facts, right, those with a financial interest could have pursued this kind of application and didn't. And so the case is a good read if anyone wants to see some thorough commentary and consideration of the issue of standing. And I thought it was also interesting where the court is is, I mean, I think were four different kinds of arguments on the point, but the court sort of shot down the argument that, the courts really need to take a broader approach in terms of their inherent jurisdiction, and the court didn't agree with that. And even though, yes, right, we have cases where the children's lawyer can step in and try and seek redress on behalf of minors or unborn, and the PGT could do the same with respect to incapable adults, right? In this scenario was certainly distinctive in that, the beneficiaries could have done that, and they didn't.
Yeah, exactly. I mean, in a sense, the applicant and I guess the appellant on appeal kind of pointed to some of those situations, the children's lawyer acting on behalf of a minor beneficiary, or the public guardian trustee acting on behalf of an incapable person, as saying, well, the people who act on their behalf don't themselves have standing.
Right.
But the court actually found it was the opposite. No, they're granted standing by various statutory provisions for the purposes of seeking exactly that relief on their behalf. So she kind of defeated her own argument.
Yeah, and I guess like the court looked at, well, if you were allowed, if you did have standing and you were allowed in, you could be making decisions that compromise the interests, right? Throughout the litigation, you could be making decisions that potentially compromise the interests of those with a financial interest.
Yeah, I mean, and the court quite plainly said that it does have inherent jurisdiction to oversee the administration of trusts. But the analogy I kind of thought of when in reading the case was that, think back to first year contracts when you're dealing with the issue of estoppel, right? You have the whole argument of estoppel being used as a sword and shield. We love our kind of sword and shield analogies in law. I see the court's inherent jurisdiction. The first thing I thought of was the court's inherent jurisdiction it's a sword that can be used to kind of oversee the administration, but it has to be wielded by someone with a financial interest. The court's not going to undertake its own kind of investigation into the administration of private trusts, because I mean that would be a massive drain on judicial resources for one. But it has to be something that needs to be undertaken by someone with an interest in the trust itself to be able to be kind of efficient in that respect.
Right.
So
and I mean it is I mean I have sympathy for this appellant and the applicant, because she was this whistleblower, and she really, I mean, 5 years later, I think this application was brought, several years after this whole matter started. So there was a real doggedness on her part that I admire in trying to, I guess, have the truth uncovered, because her position was that, well, they settled with the OSC, but their full disclosure wasn't made to the OSC. So she was really, persistent in that regard, but it unfortunately did not work out for her. And I can only imagine the sacrifice, not just the time and the energy, but the legal costs. I mean, it's a tough pill to swallow, I'm sure.
Yeah, I think the court had a lot of sympathy for her, but ultimately, they held, this isn't your fight to fight, so to speak.
Yeah.
This is someone else's battle to bring, and we admire your, again, as you said, Natalia, your doggedness, but this was someone else's battle to bring, which is maybe tipping off, kind of maybe the court saying, but we'll kind of entertain other arguments from other interested parties, but I won't speculate I won't go that far to speculate.
Yeah. And I mean, it's similar to, in passing of accounts, like normal, typical passing of accounts matters, even someone without a financial interest can, there is an ability to try and ask the court for a passing, and the court has the discretion to award it. But I just blogged on this a couple of weeks ago, where the court rejected, in one case, I think it was Klatt and Klatt, where the court rejected the applicant's relief seeking a passing, precisely for the same reason, which is that there was no financial interest. So I think this is a kind of a message to the people, a bit of a warning. Be careful about what you're pursuing.
Yeah, no, exactly. It's a good case to kind of get back to kind of basic principles about, before we even commence litigation, you have to consider, am I the best person to be bringing this litigation?
Right.
So
unless you have any other thoughts, I think think that brings us to the end of our podcast.
I will leave a link to the case in the description.
Yeah.
And otherwise, yeah, unless you have any other thoughts.
No, I think that's all. So until next time, we do want to thank you for listening and watching. I'm Natalia Angelini.
And I'm Garrett Horrocks.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog.